This is the fourth lecture in this lecture series titled Introduction to International Arbitration Practice. In the first chapter of this lecture series, we have seen pathological arbitration clauses. Note that the first chapter relates to arbitration agreements. We have also discussed various classes of defective arbitration clauses in the last two lectures. In this lecture, we will deal with the causes of pathological arbitration clauses. The first and foremost reason for pathological arbitration clauses or defective arbitration clauses is that those clauses are finalized usually at the end of the negotiations. This is because they typically come at the end of agreements. Also, because talking about disputes at the time of negotiating a deal, especially a big one, seems ominous. Therefore, parties feel like quickly completing the discussions on dispute resolution. For this reason, Redfern and Hunter, popular authors of the commentary on international commercial arbitration, call these clauses as midnight clauses. In haste, parties miss out the finer details of a dispute resolution clause, which creates a huge headache for the parties, or at least one of them, later on. Also, since these clauses are regarded as negative topics in negotiations, parties do not focus much on it. There is another possible reason for badly drafted dispute resolution clauses, especially emanating out of jurisdictions whose native language is not English but is nevertheless used for conducting business. In the Board of Trustees of Chennai Port Trust versus Chennai Container Terminal Private Limited, a 2014 decision of the Madras High Court of India, Justice Ramasubramaniam stated, the advantage that English draftsmen had was that both contracting parties in England could think in their mother tongue, communicate with each other in their own mother tongue, and enter into a contract in the same tongue in which they thought and spoke. But in India, the situation is completely different. The contracting parties, if hailing from different regions, even within the country, had to go through a thought process in their own mother tongue, translate them into commercial terms in a foreign tongue, namely English, and then have their own communications reduced into writing in English, and that too through a third party. In a similar vein, the Hong Kong High Court stated in the landmark case of Lucky Gold Star International Hong Kong Limited, a 1993 decision of the Hong Kong Court, a badly drafted clause leads to disputes and wasted costs, most of which are anathema to the arbitral process. In many cases in this region, I imagine the problem is caused by contract drafters not drafting in their native tongue, and this problem is appreciated. However, anything that can be done to ensure that arbitration clauses are clear, meaningful, and effective would enhance the arbitration process quite considerably. So, improper translation may also be one of the reasons for pathological clauses. Note that in certain contexts, not providing non-English versions of the arbitration clause may even invalidate the arbitration clause, especially where one of the parties is a non-English speaker, where such party is in an unequal bargaining position. For example, in the case of Prevost versus Phillips Petroleum, an American case, the United States District Court held. In this case, the plaintiffs were illiterate in that they did not speak English and hence could not read English. The contracts they signed were in English. They were not given a translation of the agreements and testified that they were pressured into signing them. Under the circumstances, the court concludes that the arbitration agreements are procedurally unconscionable. Sometimes there might be causes external to the manner of drafting the arbitration clauses, that which make the clause fail. For example, the death of the named party, or the named arbitrator, or the closure of arbitral institution. We saw this in the case of ACC Limited versus Global Cements in the last lecture. Even if the parties want the arbitration clause to specify the named arbitrators, drafters and legal advisors can provide for an unequivocal intent to arbitrate separately and then name the arbitrators. For example, the clause might provide any dispute arising out of or in connection with this agreement shall be referred to arbitration. So here the phrase shall be referred to arbitration conveys an unequivocal or clear intent of the parties to arbitrate. Then the clause can provide so and so shall be the arbitrator. If, say, the named person dies or is unable to act as arbitrator, still it is clear from the clause that the parties want disputes arising out of or in connection with this agreement to be settled by arbitration. Therefore, the clause which fails would be so and so shall be the arbitrator, and that could be easily held to be severable from the main clause providing for reference of the dispute to arbitration. It would also be wise to provide for the appointing authority in such cases. So, the arbitration clause may also provide in case parties are unable to appoint so and so as arbitrator, so and so shall be the arbitrator for the dispute, or so and so shall be the so and so shall appoint the arbitrator for the dispute. So, the option is to the parties. Now, it is possible that the appointing authority or the arbitral institution named in the arbitration clause may refuse to appoint the arbitrator or support the arbitral process. There could be a variety of reasons, but this is not something that is unheard of. For example, in the American case of Morse versus First Premier Bank, the arbitration clause provided for reference of the disputes to the National Arbitration Forum or the NAF. But when a dispute arose, the NAF refused the request. The reason was that NAF had entered into a settlement agreement with the Attorney General's office that it would not handle consumer arbitrations. But the agreement provided for consumer arbitration and for reference to the NAF. The court in this case refused to refer the matter to arbitration, but for its own reasons, that too that is specific to this case. The arbitration clause was construed to have provided for arbitration only by the NAF. But then courts generally separate the intent to refer to arbitration from the reference to the arbitral institution and generally enforce such clauses sans the arbitral institution. The Supreme Court of India held in this regard in ACC Limited versus Global Cements in the context of the death of a named arbitrator as follows. Arbitration clause would have life so long as any question or dispute or difference between the parties exists, unless the language of the clause clearly expresses an intention to the contrary. The question may also arise in a given case that the named arbitrators may refuse to arbitrate disputes. In such a situation also, it is possible for the parties to appoint a substitute arbitrator unless the clause provides to the contrary. Objection can be raised by the parties only if there is a clear prohibition or debarment in resolving the question or dispute or difference between the parties in case of death of the named arbitrator or their non-availability by a substitute arbitrator. This approach is followed in most jurisdictions. Courts tend to uphold the arbitration clause but appoint substitute arbitrators. As Garibon's commentary notes, courts do one of the following three things. 1. The provision is construed as a reference to the arbitral institution succeeding or replacing the previous arbitral institution referred to in the agreement. 2. The provision is construed as a reference to an arbitral institution that is having similar characteristics as that of the named arbitral institution. 3. The unenforceable portion is severed from the remaining portion of the arbitration clause, thereby construing the arbitration clause as if providing for an ad hoc arbitration clause. So, That's all in today's lecture. Do check out the references and the links provided therein, which is replicated for your convenience in the description to this video. Happy reading. Bye bye and stay safe.